We need two police officers.
Good afternoon. Today is August 22nd, 2018. It's 5:30 PM. This is the City Charter Commission meeting. We're at City Hall, so I'm going to call the meeting to order. And we first want to approve the minutes of the June 26, 2018 meeting. I understand we have a little bit of a need to fix who was here and who was present at the last meeting. And Sue, I think you were the only one absent. Everybody else was here. Is that correct, everyone?
I believe so.
Yeah? Okay, so with that fix, I would offer a motion to approve the minutes.
I will make a motion to approve the minutes.
Second? Second. Any other changes anybody noted? If not, all in favor say aye.
Aye.
Opposed? Motion carries. I'm going to dive right into the rest of this, so I'm going to, our next item is to review the written changes to the existing charter and determine recommendations to the council for future action on the charter amendment. So Roger, I'm going to turn this over to you.
Okay, thank you. Les, I don't know if Les had called me.
Oh, wait, can I say one more thing? There's been a couple complaints that we're not speaking loud enough and people are not hearing us as we speak, so can we all make sure that we speak closer to the mic? So I know like yours is quite a ways away there, Roger. Thank you.
Yeah, Les had contacted me today
Sure.
regarding a possible additional matter we could be considering. That had to do with situations in which members of the city council might be unable to attend a meeting physically, but otherwise could be present if they're away for work or a seminar or something like that. And we talked about what technology offers, whether it be by telephone, Skype, a lot of different techniques. And do we need to, or should we be considering something with our charter to allow for that? There are 3 state statutes that already address that under state law. Our charter and our code doesn't prohibit it. So I think it's something that the council could do if those situations arise. There are some requirements that would have to be complied with. You have to have at least one council member present physically. They might decide they have to have at least 3 there so that there's 3. And then there has to be at least the opportunity for someone to monitor the council member who is appearing electronically, which would be interesting. So anyway, I don't know that we need to be doing anything to the charter to allow for that.
That's fine, because it just came up, and I know there's times when one of us could be on the road at a training, but when we're certainly available to be at the meeting, offer votes, offer some input, but at this point, we didn't know if we could do that, so why don't we just set it for a future discussion item at a city council meeting then, so if everybody's okay with that. I didn't know if that was something that we wanted to, or had to add to the charter, so I called Roger, and I did talk with Nate, our IT person, and he thought with the new technology that's going on in here now that we're almost already available to do and he said we had to use our words carefully. We couldn't use teleconferencing, we couldn't use video conferencing, we had to talk about remote presence because the way the technology changes so quickly, but I think we'll just deal with that at the city council if everybody's okay with that. Okay? All right, thank you.
All right, thank you. Then to move into what I've done to actually draft some changes, all of you have, I hope, the red line versions of what I had put together. And I think to be the most efficient, what we can do today would be to go through these. If any members of the commission have any questions or comments or think we should have some different language or not do it, this would be the time to speak up. Because if we can get through these and if they look okay, then the next step would be for the commission to vote on recommending whatever changes they think are appropriate to the New Ulm City Council, and it could get on the council agenda, and then they could actually take action to make the changes to our charter. So with that kind of background, if you'd come to that part of the agenda, the first item would be a change where we are adding a comma in the 3rd line of that first page after the word powers. If everyone sees that, that would be in subdivision 4. What you're looking at is a carryover of 4, which starts actually on the preceding page of the charter. Anyone have any questions or concerns about that? Okay, hearing none. The next page would be, okay, actually, this is, okay, yep. This would be on page 4 of the published charter. This would be in section 18, in the second paragraph, about 8 lines down. Instead of using the term ward counselor, we're trying to be consistent, so it's going to read city councilor from now on. Again, anyone have any concerns or questions about that? Okay, next. Okay, the next page, you'll see there's an entire paragraph, one sentence that's been stricken out, and that's because that language duplicated language that previously appears in the charter on the same issue. So it's indicating if there's going to be a nomination by petition, the signers of the petition have to be residents of the ward for the nominee. So that language is already in the charter, and this just eliminates that duplication, if that's okay. Okay, then under form of government, section 21, the charter was silent as far as an actual authorization for the council to elect a vice president. It's something that the council, as far as I know, has always done, and this just confirms that at the same annual meeting, when a lot of its initial appointments and other decisions are made, that they would also elect the vice president.
So just let's make sure we add an E in there, so it's not a vic president, it's a real vice president.
Well, if you want the vice, we'll...
I want a vice, I don't want to be a vic,
Okay.
or whoever.
It's your call. We'll make that note. Then, under 22, the commission wanted to make sure that the charter provides for establishing a human rights commission. These are the commissions that the city needs to establish. They can have other commissions at the discretion of the council, but these are the ones that would be mandatory. So, as written, the charter would require the Board of Health, which we talked about, the PUC, the Fire Department, the Human Rights Commission, and the Police Commission. So if you think those are the ones that are essential and they should be part of what is appointed every year, that would now include the Human Rights Commission. Any questions on that?
Roger, I have a question going back to section 21.
Yes.
The duties of the vice president and probably, in fact, the president as well, are they defined, like is the council using Robert's Rules of Orders or something like that?
That's always been my position. I don't believe there's anything it's not in the charter, and I don't know that there's anything in the code. My position is that if we really get into procedural issues, it's the most current version of Robert's Rules of Order.
I think it is in there somewhere that the city council shall follow generally the Roberts Rules of Order. I think I've read that somewhere.
In the handbook, isn't it? I think that's where I'm thinking I read that.
I read it somewhere, yeah.
I don't think that it's in the code. I might be wrong, but I don't believe it's in there. So, anyway, it's something it would help to eliminate any confusion if there was any dispute. At least that way you would have some authority. And I
Right,
know people, all of you have probably been on various boards or things, it's not like Robert's Rules is exactly ideal. There are plenty of people who do this all the time, who think that they're cumbersome and they're obsolete, but they're there, they're generally accepted. At least it gives us some format. So if you think it would be good to put that in, I mean, I think it would be appropriate to have it in the charter if you wanted to make sure that it was clear that these are the procedures or the rules that have to be followed if there ever is a dispute.
I think it makes some sense because it doesn't, if you define a vice president by council or action, but his or her duties are not defined, it's kind of loosey-goosey.
Well, and those things, to the extent of the duties for any particular position, I mean, that also could be appropriate, to include in the charter. I think that there is language in the charter that generally indicates that in the absence of the president, that the vice president conducts the meetings and otherwise assumes the duties of the president. So that much is covered.
There's, breakdowns of each section, because the same thing as if the mayor's gone, it should be the president's gone, then it's the vice president that would take over the mayor duties. I know that's in there,
It's in the charter.
in the charter, yes.
Under council procedure, it says, section 61 says, "The council shall determine its own rules and order of business and keep minutes of its proceedings." So I assume it's up to the city council then to say, we adopt Robert's Rules of Order.
Unless we
If
would
they
change it.
choose a different, right, but this doesn't designate Robert's Rules of Order, it just says that the council should.
Exactly. That's
just
why
so
I'm saying
that-
it's not in there.
Right, so do
Um,
you,
So I guess that would be something where if the council was, I mean, if this commission is concerned enough that you think it should be, I mean, this is your recommendation. If you think the council should be required to use it, we can recommend that they include that. If they don't want to do it, I mean, they don't have to, accept the recommendations of the commission, I guess. But, I mean, another way of taking care of that concern would be if the council were to adopt a resolution just confirming that that's.
You have to use, I think, sometimes the correct language, because the true Robert's Rules of Order, I don't think anybody really follows.
Well,
to
that's why I
the
say,
T.
well, I usually, when I've had to do this for other organizations, I've always said the most current version, because they keep amending it. And people will pull out one from 1925, and it's not the same as the most current version.
But even the current version, I think Charlie's current procedures is he's a lot more lenient than I think what Dan Bernick's, when he ran the city council, as far as allowing people to speak or, all those little tiny rules that Robert's Rule says you have to follow. And I don't know if we want.
I would not recommend putting that in the city charter. Let the city council run their meetings how they deem fit.
Okay, no, I mean, that's a very legitimate position, Bill.
I think
mean,
sometimes that
that's,
is the president's role to
Yeah.
decide how they want to run their meetings.
I did just note in looking for that, though, that the charter already says in section 63, the council shall choose one of its members as vice president, which we just added to section.
Well, but it doesn't say when, does it?
Yeah, at the next annual meeting following a regular municipal election, the newly elected councilors shall be sworn in, and the council shall choose the vice president. Section 21 is elective officers as in elected by the.
Well, we should probably take a look at that, because the next annual meeting, right, okay.
Right. My point is that what we just put into 21 might already exist in 63.
Yeah,
Because 21
you.
relates to elected by the electorate. 63 is organizational, elected by the council.
right. So I think with what you have discovered, I would recommend let's drop this language. We just made
Unless this
a
was
little-
supposed to be a Vic. This is the Vic president.
Maybe, or maybe there's another name.
21, and then we'll.
So since we have voted to put that in, we probably need a vote to take it out, right?
So
I don't
we
think
haven't voted on
we
anything.
didn't vote
Oh, we
for
haven't voted.
anything.
Okay.
Yeah.
So we could just remove it then, if we're okay with that? As long as it's already covered in the other category? All right,
Yeah,
Yeah, I'm good.
we're all okay with that? All right, go ahead.
yeah, all right. Then,
Good catch.
okay, section 48, we just were missing the word "than," so we would be adding that. the same way. Oh, okay, again, section 53, changing ward counselor to city councilor. Okay, and section 66 is a very substantive change. There, what we're doing is eliminating the requirement for the 2 public readings before a new ordinance can be voted on. The new language states that other than emergency ordinances, which are a different issue altogether, they still have to be considered at 2 meetings. So it's not going to be something that can just be done after 1 council meeting. The vote can't happen until the second meeting. Previously, we had this requirement that I think there has to be a 3-day waiting period between the first and second consideration. Under state law, we're obligated to post the ordinance on the website. And if we don't have an electronic notification system, which I believe that we do, if there are people who want notices, they're entitled to get it by email. But if we wouldn't, then we have to post it 10 days before the meeting where it'd be voted upon. So the idea here is to eliminate, and this would eliminate even the first reading. And I guess the more I think about this, what the council's doing with ordinances is obviously one of the most important things that happens with the city. But when you look at what happens with our state and federal laws, Congress is not reading the new Internal Revenue Code before they vote on it. Maybe they should. But, this is something where at the state and federal level, no one is having to read this. I think that's a fairly archaic requirement. But a lot of times it really is important to read the language before a vote is taken. I'm sure the council does that. So anyway, that's the new format that would be implemented. There's still going to be on the agenda twice for 2 separate meetings, but there is no actual reading that is going to be required.
So the only thing I would just add there is, kind of in the middle there, it says at least 3 days shall lapse between the first and second consideration of the ordinance. And then in the next sentence, it has to be at least 10 days on the city website, which basically is between meetings because it's before the final vote.
Right, and that would be something where,
So why wouldn't they just
typically-
both be 10?
well, typically when these ordinances come up, and we can do that, but they're known about in advance. It's something that's discussed, and it would be, it would be given to Nicole's office. I think we could do that certainly 10 days before, that second meeting. So, but if you want to, it would be more consistent, I guess. It's just the 3 days is there, I believe that's a requirement of state law, just so you don't, have an ordinance and then tomorrow you're going to have a special meeting and consider it and boom, now it's going
Yeah,
in.
absolutely. The time period is,
Here's a concern, I think we talked about this last time, is if you're sitting at home and you're watching a council meeting, as everybody does, and there's an ordinance which used to be read, and however, we all kind of pain at some of that, at least if you had an interest in that, you could pay attention and figure out what it was. Under this particular situation now, you might not have any clue what that new ordinance is about. So I thought we talked that our city attorney would give a synopsis of what that new ordinance was going to be about. Did we not?
Well, if you want to require that, we could.
I think
I don't know what you mean by a synopsis. If we have a new zoning ordinance that's 45 pages long, it's something that's going to be really important, and presumably, Dave Schelberg would be talking about it, and everybody involved would be talking about it. But what do you mean for a synopsis? We're changing the zoning ordinance? Here it is.
Just an explanation that if somebody is watching on camera or they're at home, that they would have an understanding of what that ordinance is all about. And it's because it's now going to allow chickens in town, and here's what this is all about. Or it's I just think we have to
I
do
mean-
something.
Well,
I don't know what that is. It could be explained by a city council or by city staff or by city council or something like that. Would that, I think there has to be something there. Otherwise, I'd be pretty frustrated if I was sitting at home not knowing what the heck are they talking about.
Sure, but then your remedy is call your counselor and say, what the hell did you just do? Vote on something without even discussing it on the record.
Roger, you put that in there, but I don't have to make the motion to waive the reading. I can, if I'm, a counselor can still say, no, I want it read. This gives us the right,
Well,
we don't have to do it.
this would assume there would not be a reading.
right,
And I guess if the council says, no, I want you to read that in the record, I mean, yeah, we'll read it into the record.
But I can just see what's going to happen is one of us is going to take on that role of explaining what that is, and I think that probably should come from you, more than maybe from a counselor. I don't know.
Whatever, but, I mean, yeah, it's whatever you guys want to recommend.
I think it's hard to require, it seems a little vague, how you just put in that you gotta do a synopsis, because
Some of them are that
What-
long, and then some
I
of them are really
understand.
long.
Yeah, I
Right, but
understand.
the question is, does it have to be in the charter? So
Right.
you're correct in identifying a problem, that the public wants to know what the city council is doing, but you're a city councilor, it's your responsibility to make that record.
Yeah,
Does that?
Yeah, I think if
do you
I
need
would-
the charter to tell you that you need a synopsis in order to make sure that you do your job.
good point. Maybe we
If I
can
was a city councilor and I knew that it was important, first of all, when you read through all those pages, people are probably not gonna understand most of it anyway.
Oh, it's
but
horrendous, some of
you-
them.
You would want to just inform people the basic gist of the
Right.
ordinance. But I don't know how you make that a rule or an exacting rule, but I think you just do it out of maybe common sense courtesy.
And I think without, I mean, if this goes into effect, I'm sure that between the council and city staff and our office, that is just the way they should be done. At least, probably the first time it's considered and the second, just to remind people. The agenda is something that's available online. I think the language would be there for people who are really interested. If they don't have online access, they're entitled to get a paper copy, and it's not like it'll get ramrodded through in one meeting.
Right.
So if it comes up, and well, what exactly does it say, they're going to be able to get a copy.
Because the most horrendous ones are the land ones, where it's lot 1, block 2, I mean, just anybody watching that has no clue
No.
what anybody's saying. So, all right, I think we can settle it that way. Thank you. Let's move on.
Just for additional information on this particular topic, in 2017, Governor Dayton signed into law, went into effect August 1st, that, so state law, at least 10 days before City Council schedules a final vote on a proposed ordinance or proposed amendment to an ordinance, they must provide email notification to those that have asked for it, post a notice in the same location as other notices, and update the city website with the proposed ordinance. It is in state law that you have to have 10-day notice.
Yeah, that's why it's in there.
Yeah.
Yep.
Okay.
And so,
So the 10 days would be before the second meeting.
correct.
So you may have the first meeting 7 days after it's posted, and on the 10th day, you could vote on it.
And again, I frankly don't know of any situation where there's been an ordinance that hasn't been considered at 2 regular council meetings.
Right.
Now, Brian, have you ever seen that come up? Yeah.
The only
So-
time it would come up would be emergency ordinances, and interim ordinances are not subject to these regulations. So quickies that just have to happen. So, the purpose for this is those communities out there that don't read, they don't synopsize, they don't do anything, and they just pass it. And the state says, the public has a right to know what you're doing. And so they're basically forcing us to put it on the website if we have a website and post it where we need to post it. So I think it's, the state's got it covered. I think 10 days is fine. You want to coordinate the 3 days, kind of saying you can't do it 3 days. Put 10 days in there and you're in lockstep with the state law.
I think you're right. The constituents are going to be crabby if they're not knowing what things are about, and they're going to let us know. So,
Well, I mean, again, I've never seen a situation where a council has wanted to vote on an ordinance, the second consideration sooner than the regular meeting, but
Right.
if you'd rather have that 3 days stretched out to 10, there's nothing wrong with that. That 3 is the minimum, but if you'd like to go 10, I can see reasons to do that, have it consistent.
If it hasn't been an issue, I don't see a need to change it.
The other item that goes with that law was failure to provide this notice is not invalidated and adopted ordinance.
Right, so, yeah. So, the so what, yeah.
Is everybody okay with the way it's at?
Can I ask a question on
Yep.
clarification?
Yep.
On the second paragraph, Roger, if the city has an electronic notification system, it must notify a person of the notification procedure at the time the person applies for a new business license or renewal. Why is that in there?
That's state law.
It is, huh?
Yep.
Okay.
Yep, and I was frankly kind of surprised to see that, because I thought that was really an unusual provision.
Yeah.
But I guess if they're concerned that people who have got licenses might be affected by changes to the ordinances, that they might want to get this sort of notice, but yeah, it's actually in the state law.
Okay,
So-
thank you.
Anybody else? We're all okay with that? All right, let's move on.
Okay, then, the next one is section 74. We need to designate an official paper. Because, again, I mean, the New Ulm Journal has not been published in the city of New Ulm for 50 years or more. We've probably been in violation of that all this time. So anyway, I deleted that. So it just states that we have to designate the legal newspaper for publishing notices, ordinances, et cetera. But then I did add that the council would give priority in its designation to a newspaper published in the city. So I think published would be the editorial offices, printed is, of course, where it's physically made. So if that would be acceptable to people. Okay. Okay, then I think the next one is sections 98 and 99, Fire Department. This is a substantial change, and a lot of this is attributable to the fact that the chief is a full-time employee, with the changes that have been made on that. So this would say that the chief would no longer be elected by the department, but rather appointed by the city manager, subject to the approval of the council, and that the chief has the authority to enforce all the ordinances of the city relating to fire prevention, and then the right to enter and examine buildings, parts thereof, reasonable hours for the purposes of enforcing the ordinances. And then the language about the fire marshal, that is, the entire section is deleted, because those duties are going to be performed either by the chief or by his designee. So, and then section 100, to clear that up, and it's not talking about the fire marshal, just that the compensation that the chief would be received would be determined by the city manager, like other city employees, subject to the approval of the council. So any questions on those? Okay.
Nope.
Then, next is 158. That's just clarifying the fact that the city council has got the care, supervision, and control of rights-of-way, highways, streets, alleys. You can have an area that's been designated a right-of-way where someone might take a position, it's not an actual street. This would just clarify that as long as it's a public right-of-way, that the council has authority. And likewise, the next section, 159, says that the same thing would apply. The city council has the authority to lay out or open rights-of-way, streets, et cetera, and to close the same, including rights-of-way. So if there's any question on any of those. Okay, yeah, then section 171 This just clarifies the notice provisions. If there's any person who would want to assert a claim for damages against the city, it now says that they have to just present it to the city within the time period required by law, consisting of a written notice, so that I think in the real world, that's what tends to happen. This stuff usually would go to the city manager, the finance director, possibly my office. Many times, these are nominal claims that are covered through our league insurance. We make sure they're promptly submitted to make sure we have coverage going into place. I think anything that's significant, important, could involve litigation is going to be brought to the council. But every little claim that, somebody dropped too much dirt in my yard when they were doing some excavating, I want it cleaned up or whatever, is not going to require council attention. Okay? Then section 180. This is another substantial change. The purpose of this is to ensure that there's no question about the city's ability to deal with nuisances, which would include blight. This is modified a bit to make it conform to state law as far as what can be required of property owners, to give them, they have to be given notice of whatever the problem is, an opportunity to address it. If they fail to do that, that's something that's covered by specific ordinances. Usually there's a minimum of 7 days unless it's a true emergency. That if they do not address it on their own or on their own, at their own expense, the city has got the right to take care of it and to be paid for the city's costs in having to do so. And if the property owner does not, the responsible party does not pay the city would have the right to assess the cost back against the property. We just want to make sure that there's not going to be any dispute or any challenge to the authority of the city to do it if they have to go through all of that.
And this is actually what brought us all here tonight.
This is one of the
This
major
was
things, right?
The one that
Yep.
we had to open the charter to fix this.
Yep. So,
I have a question about this. Let's just say that I own property downtown. It's a business, and the business is no longer open. Inside this business, I'm storing numerous items, and the building is for sale. But the building, when you go into the building and you look at the building is such that it may not be safe. Does this fall within blight, public health, or a safety hazard?
That's a good question, because that comes up.
If the business is for sale, or even if the business was not for sale, could that also be blight, public health, or a safety hazard?
I've had a number of conversations with Elwood Zabel, our building inspector, on that, and it has come up on some particular properties. At this point, the state law restricts his ability to act on internal issues to something where we would know or have reason to know that it's a safety hazard. If the person was storing open containers of gasoline or something otherwise, that obviously dangerous, the city would have the opportunity to take action. If, he would conclude that the exterior walls are ready to fall down, action could be taken. Otherwise, the way that the code is worded and the state law is worded, most action relates to things that are visible from the exterior. Weeds, blight, improper storage of vehicles, things like that. So the question of, okay, there's a building there, I think the toughest ones are sanitary, where if there are rodents, things like that. Generally, rodent infestations, I think, are considered a safety issue where the city can act. But the fact that, if you
Doesn't
open the
public
door,
health-
the place smells, or there, things like that. There are problems that most, I think, reasonable people would say, this isn't right, this needs to get cleaned up, et cetera. But it really would have to be a definable health hazard before the city normally would get involved.
Does it make a difference if the property is for sale or
No,
not for
no,
sale?
I mean, that's something, the property has got an owner, and part of this, whether it's the police or the inspector, when they're investigating it, I think there's a couple things they look at, certainly who's the owner, but also who's the occupant. If you've got a tenant in there, and the tenant's got the right to the exclusive possession, and there are issues, it could be the tenant's problem. The tenant might say, well, I have a lease that says the landlord, the owner, has to fix this. And that might be, and I think, we'll certainly listen to that. But if there's a problem, someone's going to have to deal with it. But no, the fact that there's maybe an absentee owner and it's for sale, or they've been trying to sell it for some time, that doesn't matter. What matters is the condition of the property.
This section does get a lot at those abandoned homes that are maybe, the owners are live in another state, and there just sits this home and they don't care. They write their check, they pay their taxes, but then the house just starts falling apart. After 20 years of it just being abandoned, or people are dumping garbage in their lot, and this would allow us to do some action if we wanted to, or need to.
If it violated
If it
other
violates, yeah.
provisions of the
Yep.
code. I mean, like everything, the guys who are in the trenches who have to deal with this,
Right.
if you have someone who's gone for a year and there's some paint chips that are appearing, somebody may not like that. If you have someone who's gone for 20 years and the roof is falling in, it's a different story, and we see
Right.
everything in between. So you just kind of have to handle it on a case-by-case basis.
Thank you.
So any other questions about 180?
Can we really call it 180, since there's a 180 that's been,
Well, we're going to have to
Appealed
correct
or-
that, because this is a new
Oh.
provision, and in looking at it, I was considering how to number it. I guess when this would go up, we would ask that that language about section 180 being repealed would be changed, because otherwise, I suppose we could add it as a new 192, I think, unless that's...
there's a 192 also that was repealed.
Right, I think that's the problem, is we're kind of running out of numbers here. And I wanted to keep it in that part of the charter.
We make
Right.
it can we just make it a 180.5 or something like that?
Well, none of the other ones do that.
No?
I mean, we
Can't you
could,
just say
but,
this, repeal and replace the existing 180 or something?
yeah. I think that's more just a matter of how it would get entered.
Just-
We had
yeah.
talked about all this language in here about these things being repealed. There are reasons to do that. And we could probably include some language at the end of it, because for each of these changes, we're going to get to make these notes about amended. If the council would follow all the recommendations of the commission. If you look at like 178, it's got the two amendments. There would be another amendment indicating the ordinance that did it. And what we would probably have to do would be to say original section 180 repealed by that ordinance, new section 180 adopted by whatever the new ordinance would be.
Well, this will all be important when people need to determine if it's a living and breathing constitution or a static
Right.
charter, or the proper, interpretation of the language,
Right, 20 years from now, when somebody else is
through the
doing
legislative
this.
history.
Right,
Yeah.
yeah, and sometimes that's important when,
What were they thinking in 2018?
why did they do that in 2018?
That's a good point, but I think, that's probably
Roger
how we'll do
Hibbert,
it.
that guy?
But he died.
Wishful thinking.
You'll find a new number for that, so I don't want to spend time on that tonight.
Yeah.
Okay, then,
I trust you.
section 243, okay, that is on the advertisement for bids. Yeah, that is because there are a lot of different ways to advertise for bids. And it's something where, the council might decide that, considering the nature of the contract that's being considered, the council might, require, or the state law might require something, that in addition to this publication, you have to put it on certain websites. So we just want to make sure that it's going to state that if we're bidding things out, that we're going to be complying with the law. So,
That's really the last one, right?
I believe so. Oh, no.
No, there's
No.
no more.
It was section
more.
247. That's the question of accepting bids. And that language, I know there was discussion about why was that exception in there regarding the time of performance.
Oh, yeah.
So, here, part of that might be an interpretation of default. I mean, default is something that's enforced by the city. I think in a situation where there were weather delays, strikes, whatever, that prevented a project from being completed on time, I don't know that the city is going to consider that a default. If someone has defaulted in performance without that type of a legitimate excuse, I think the consensus was that should be something that the council could consider. If we gave them a big job and, they didn't get it done, and we were fighting with them about the late payment penalties, and now they're the low bidder on this year's project, is that something where we're going to have to consider giving it to them even with the bad job, timing of their last performance? So anyway, that's the reason why this would have been stricken out, if you want to recommend that to the council as well. So any questions on that, or getting back to any of the things we discussed, any other new matters? Again, this is a standing commission, so as things might develop in the future, if issues come up where the council wants us to reconvene, that'll happen. I think if the commission members would have concerns about something that the council has not raised, you could probably reconvene. But it's not like, this is it and it's all going to be done tonight.
And there's no finite terms to this commission either. You're on here for the rest of your life, or unless you choose to resign. So if you do resign, make sure you let the city staff know, and then we'll have to reappoint somebody.
Right, and I guess what's likely to happen, that's a good point, Les, what's likely to happen is this commission may not have any activity for quite a while.
You might not.
And if it's going to need to reconvene, everyone would get notice. And if at that point you just, felt like you no longer wanted to serve, please let the city know, because there are some timeframes we have to comply with to
Right.
get a replacement appointed by the district court.
Technically, there are terms, or four-year terms.
Yep.
Some of you are two-year terms, and
That's
some of you
right,
are
yeah.
four-year terms.
Is there terms on here?
Yeah, I think
Oh,
it's,
okay.
that's
I
in
always
the
thought it was
court
an
order.
infinite.
No, the
forever.
commission itself
My fault.
is, but
I'm
no,
sorry.
your terms, come up. And that's something where, we'll need to keep an eye on that and make sure that we always have a commission. That's one of the things, because it just kind of lapsed, and I think the assumption was the commission itself no longer existed. Legally it did, but we didn't have any new members, and everybody's term had expired who was on the original commission. So that's how we got where we are today. But
So do somebody need to make a motion to pass these
Yes.
changes on to the city council?
Mhm.
I'll do
Is that a
that.
motion?
Sure is.
Okay, we have a motion. Do we have a second?
And Linda, that is with the understanding of the one deletion that we discussed as far as not.
Moving the vice president.
Twice, Yep, okay.
I'll
Second.
second.
Motion and a second. Any other discussion on these topics tonight? Hearing none, all in favor, say aye.
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 Opposed? Motion carries. And with that, I thank
Wait.
all of you for your time and,
We do have a committee yet to discuss the potential ranked choice voting. It's kind of,
yes, a
there's three of us who will
subcommittee.
work on that, and would, if we have a recommendation, could come back.
Yes, so why don't we talk about that after this meeting a little bit, about what we
And I
wanna
think
do.
with the vote having been taken, my intention would be to make the final changes to these. forward them to Nicole and Brian to get them on the agenda. I'll copy all of you on that. And if there would be any last-minute things, or if you thought in the final version I got something wrong, please let me know. But we'll keep you in the loop on that.
What's your projected timeline on that?
Well, the next meeting is the 4th. No, I mean, I think
kinda
they're.
done, but-
Right, it's pretty much ready to go. A lot of stuff on the 4th, or don't we know yet?
I don't know yet.
Okay. Well, I mean, I would think we could get it there, so it could be on the agenda.
One of
for
those
that.
2 meetings, probably.
Yeah, I think the soon, and I don't know where, like Dave might be at with his zoning ordinance. I have a hunch that's not coming up on the 4th. But we definitely want to get this change in place on the reading before the council has to deal with that.
And if you can attend that with all your work, I'd appreciate that. If you can't, that's understandable as well. But again, thank you for your time and commitment in getting this process through
Absolutely.
this commission and off to the city council, so.
Yeah, there
thank
were,
you.
from my perspective, there were some very insightful questions
good
and
discussions.
comments and suggestions. This is a good commission, so.
I just, maybe a question for the city attorney on this particular topic, and that just, it's more or less the logistics of this. And I guess the way I read the league handbook that talks about how do you change your charter, it basically says if you're going to change it by ordinance, that the city council could have prepared an amendment and offered it for you to review, or, as we did this time, they said, go look at it, and we had a couple ideas of what we wanted to change and add. But that collectively, as all the amendments that we have changed, that this goes as a lump sum package. This isn't like the city council gets it and then says, I agree with the first 3, but we're not going to do the 4th one. This, as I read it, is the city council has to either accept the one they supplied or the one the charter commission supplied.
That's how I see it, too.
And carry it forward. And they talk about the amendment. They don't talk about the amendment. So I don't know if they're assuming that there's only going to be one amendment, or are they assuming that we're going to have 14 of these, amendments, and we carry that forward? So that's the question I guess I posed to the city attorney.
Yeah, actually, I want to take a look at the statute and see if there's been any case law interpreting that, because I could see where that could be interpreted either way.
Yeah, because last time
'cause
when
what-
we did it, it was like, if memory serves, it was all or nothing, or the city council could have kicked it back to the charter commission and said, we have some concerns, about this or that. And if they felt strongly about, whatever position, then they'd give it back to the city council and say, here's the deal. But I point that out just so everybody knows the process. And Roger, he can get back to us on that whenever, but it'd be my understanding that it's lump sum. Here it is, because we're not going to have 14 ordinances, each one being a separate one of our changes. It's going to be one
That's how we did it
ordinance
last
with all
time,
the
right?
changes.
That's what I remember how we did it last time.
Yeah, yeah,
Because the controversy with the law enforcement thing was in there last time, and
yeah,
so I remember us saying you had to prove it all.
yep. It's my understanding it's all or nothing, but I just I think everybody to, kind of understand that.
Yeah, and for one thing, this is not going to be on the meeting for the 4th, because that rest of that statute that Brian's been referring to says within 1 month of receiving a recommendation, the city must publish notice on the proposal containing the text of the amendments, and the city council must hold public hearing on the proposed charter amendment at least 2 weeks, but not more than a month after the notice is published. So I guess, and I would assume at this point from your office, Nicole, I don't know if this recommendation comes in through me, if the council has to order it published, or at this point it's a recommendation if you just go ahead with the publication. I haven't had to do this before.
I can't remember what we did last time, it was so long ago, but I think just from a procedural basis, the council, according to that language, has a choice of doing their own or accepting the charter commission. So to me, they would need to accept the charter commission and then start the process. But that's up to, Roger, you can do the finer detail of the law, but it just seems like a logical extension that if the council has the choice, you would publish both of those. You would only publish the one that the council said, this is one we're going with. And so it seems like it has to go back to the council, and that starts the clock, that starts the process.
Well,
But you
I
tell
mean,
me.
there's not a problem with doing it. I mean, the state law says, within 1 month of receiving a recommendation to amend the charter by ordinance, the city must publish notice. So this is the recommendation, what's been voted on tonight. And when that's received, which I think would be when I would forward it. And frankly, take a look at what was done last time. I might have something prepared for our chair to sign, just to confirm that at this
Sure.
meeting, this was what was voted on by the commission, and so it complies with that part of it.
Yep.
And then
Well, I think the technical part, city attorney's office
right.
can drive
Yep.
that aspect. It's been adopted here, and we can put whatever documentation we need to comply with the law, and we'll carry it forward, so. We'll just wait for Roger to lay the blueprint out on this is how it's gonna be done, and then we'll.
And I'll
Follow
keep
that.
the commission in the loop so that all of you know where it stands. So we will keep it moving forward.
Great. Thanks, everybody. Have a good night. Meeting adjourned.